This is an open hearing of the independent inquiry into matters relating to Afghanistan. Please could I ask you to ensure that all mobile telephones and other personal electronic devices are either switched off or in silent mode. Please may I also draw your attention to the fact that the Chair of the inquiry, the Right Honourable Sir Justice Haddon-Cave, has made a restriction order in relation to the conduct of those who are attending the hearing. The full order is displayed on the inquiry website and on the door of this court and of the media annex, but I will summarise its purpose. The first part of the order, which applies to this and to all future hearings of the inquiry, prohibits any person from making an audio or video recording of inquiry proceedings from within the hearing rooms without the express permission of the Chair. Furthermore, no person may take a photograph in any room in which inquiry proceedings are taking place and at a time the inquiry is sitting without the express permission of the Chair. For the avoidance of doubt, both of these prohibitions extend to the hearing in the media annex. The second part of the order, which applies to the hearings scheduled to take place this week, arises as the live stream of these inquiry proceedings via YouTube will purposely be subject to a 5-minute delay. It is prohibited that any person may disclose, publish or broadcast in any form or by any means anything that is said or done in the inquiry hearing room until 5 minutes after it has taken place. If an application is made for a restriction order in relation to anything that has been said or done in the inquiry hearing room in the preceding 5 minutes, anything that was said or done during that period is subject to a restriction order prohibiting its disclosure, repetition or duplication until the Chair has finally determined the application. All of the above orders are subject to a penal notice. This means that any breach of any element of the restriction orders may be certified to the High Court or the Court of Session, who will have the power to fine or imprison anyone found to have been in breach of the order. Court rise. This is an open hearing in Court 73 at the Royal Courts of Justice as part of the independent inquiry relating to Afghanistan. The hearing is before Lord Justice Haddon-Cave, the Chair of the inquiry.
Good morning. Mr. Glasgow, I gather that the transcript from yesterday's proceedings is now up on the inquiry website.
So yes, that's correct. So before I return to deal with the remaining part of the opening statement for counsel to the inquiry, can I just deal with the timetable for this morning?
Yes.
I've spoken with my learned friends who are due to follow me. I anticipate that I will be done within about 30 to 45 minutes. It then seems sensible, having spoken to my learned friend Mr. Altman, King's Counsel, if there is a short break before he begins his opening statement. I understand from him that he will be no more than an hour. Then, having spoken to my learned friend Mr. Greaney, King's Counsel, he has suggested that there would be a short break before he begins his address, and again he is confident that he will take no more than an hour. That should see us finish around about lunchtime or possibly just a little into the luncheon adjournment. Having spoken to everyone, and in particular my learned friend Mr. Hermer, King's Counsel, he has asked if he could begin his opening statement on Wednesday morning. That would have the advantage for him of being able to deal with his opening statement in one piece and in the one day. And he's kindly indicated to me that he is likely to take up most, if not all, of Wednesday. There are, of course, additional days timetabled this week, and if we need to use them, we can. But can we revisit the question of any additional time at the end of tomorrow, once my learned friend Mr. Hermer has reached the end of the day?
That's all fine, Mr. Glasgow. I'm very happy with those arrangements. Good. Thank you.
So I got to a point yesterday afternoon where we'd embarked on a consideration of some of the contemporaneous allegations and the investigations into them that had been carried out. and I was about to turn to deal with the Royal Military Police Operation Northmoor. In 2013, the solicitors firm Lee Day raised a series of civil complaints seeking damages against the Secretary of State for Defence for the mistreatment of Afghan detainees by members of British Armed Forces. The civil litigation that ensued led to the Royal Military Police investigations under the title Project Elsinore. At the same time, the Royal Air Force Special Investigation and Intelligence Branch was conducting investigations into allegations made by Afghan detainees that they had been subjected to assaults and mistreatment whilst in the custody of British Armed Forces. The RAF SIB investigation was given the title Operation Isotopic, and when the inquiries were concluded in December 2013, jurisdiction was handed to the Royal Military Police. On the 17th of March of 2014, the Provost Marshal Army, who is the Chief Officer of the Army's police force, directed that both Project Elsinore and Operation Isotopic should be joined to ensure that a prompt, effective and properly resourced investigation could take place into all of the allegations. The investigation was to be conducted by the Special Investigation Branch of the Regiment of the Royal Military Police and was titled Operation Northmoor. The original terms of reference drafted by Provost Marshal Army for Operation Northmoor directed that the investigation must focus on the following. First, the investigations of all criminal or non-criminal conduct that has been alleged by the complainants as outlined in pre-action protocol by Lee Day solicitors contained within Operation Elsinore. Second, the investigation of all criminal or non-criminal conduct that has been alleged by those detainees within Operation Isotopic. Third, establishing if any new information within 1 or 2 would require the re-examination of active investigations or those already concluded by 62 Section SIB or the Royal Air Force Police under the Tri-Service Investigation Policy. Fourth, determining if there are any systemic issues identified which may amount to criminal or non-criminal conduct offences. And finally, fifth, providing immediate advice to the chain of command if by their investigations they discover a matter which could prevent an offence or systemic issue continuing. When it was first set up, the command structure of Operation Northmoor saw Provost Marshal Army as the Gold Commander, and as a result he was responsible for oversight and strategic direction. His deputy, the Silver Commander, exercised overall tactical command. But in June 2014, Provost Marshal Army revisited the command structure and replaced himself as Gold Commander with one of 2 Royal Military Police SIB officers of Lieutenant Colonel rank. Additional advice and support was arranged by the Gold Commander using an external policing agency, members of whom were engaged to provide independent advice and who made recommendations on how the operation could be most effectively progressed. Provost Marshal Army was clear in his initial direction that this was required to mitigate risk at any potential judicial forum, to show that careful consideration has been given to any concerns about a perception of impartiality. Whilst Operation Northmoor was originally concerned with detainee mistreatment claims, in October 2014, an allegation of unlawful killing by UK soldiers was made by one of the detainee mistreatment claimants, Mr. Mohammed Bang, together with a family member of those who had died, Mr. Saifullah. This allegation of unlawful killing was also brought within Operation Northmoor. The date of the allegation was cross-referenced with operational records, and it was identified as the 4th example I took you through yesterday, known as Objective Tyburn. Initially, Operation Northmoor was staffed by 9 personnel, but by the end of 2014, the proposed staffing requirements had expanded to 123. An investigation of this size required specific premises and IT infrastructure. However, it was not until July of 2015 that RAF St Morgan was identified. Initial operating capability at RAF St Morgan was declared in January 2016, but full operating capability was not reached until August of 2016, over 2 years after Operation Northmoor was first established. Operation Northmoor was split into 3 teams. Team 1 dealt with the unlawful killing allegations. Team 2 with the detainee abuse allegations. And Team 3 provided the supporting elements. Each team had a senior investigating officer at its head who reported to the Silver Commander. At its peak, Operation Northmoor had well over 100 personnel. However, the vast majority of those were assigned to Teams 2 and 3, with Team 1 reaching a maximum of 23 officers. In reality, the majority of Operation Northmoor personnel were engaged with investigating in excess of 670 detainee abuse allegations, and this continued until those investigations began to be closed down from 2017 onwards. Team 1, charged with investigating the unlawful killing allegations, concentrated on gathering supporting material for Objective Tyburn, the DDO that was carried out by UK Special Forces by the subunit commanded by N1141 on the 16th of February 2011. And it was the DDO which I described to you yesterday, in which 4 people were killed. This included the search for contemporaneous documents and also gaining access to computer servers used by UK Special Forces. The data recovery side of the investigation was particularly challenging given the amount of material, its security classification, and the ongoing operational security issues. These challenges continued for the life of Operation Northmoor. In January 2015, during the course of these inquiries, N1466 approached the investigation regarding his knowledge of allegations of unlawful killings. In April 2015, N1466 informed Provost Marshal Army that there was an apparent disparity between the number of EKIA and the number of weapons recovered. N1466 also informed the team that there was a controlled access security compartment that had been set up to protect contemporaneous anecdotal information about alleged extrajudicial killings. The contents of the security compartment were recovered in June 2015 and they were reviewed. Within the contents was the typed document from N1799 dated the 24th of March of 2011, in which he had recorded the conversation he had had with a member of the UK Special Forces subunit who had told him that all fighting-age males are killed on target regardless of the threat they posed. N1799 was interviewed in July 2015, and he agreed that he was the author of the document, that the contents were correct, and that the member of the UK Special Forces subunit with whom he had spoken was N1201. Thereafter, N1799 refused to provide a witness statement since he did not want his name to be disclosed, and subsequently he refused to speak with the investigating team. Team 1 was also investigating the use of throwdowns or weapons placed at the scene of unlawful killings to create the impression the deceased had been an insurgent, and conducting further research as well on the other 10 operations which had formed part of the TTP review of 2011. In February 2016, on the advice of the oversight team, Operation Northmoor designated 2 individuals as suspects. The first individual was N1141, the officer commanding the subunit that was responsible for the DDOs that were being investigated. and second, N1201, who was believed to have confessed to N799 that there was a deliberate policy of killing fighting-aged males. Plans were put in place to arrest them, and consideration was given to the use of overt as well as covert tactics by the team in order to identify other individuals who might have been involved, or to establish whether anyone in the chain of command might have been complicit in the incidents being investigated. Ultimately, neither N1141 or N1201 were arrested or interviewed, and only a few months later, the overall strategy was changed and the use of any covert tactics was abandoned. In July 2016, a new Provost Marshal Army was appointed, and he immediately directed that an experienced prosecuting King's Counsel and a former Chief Constable be engaged to form an independent advisory group in order to provide assistance to the Royal Military Police team for Operation Northmoor. The independent advisory group were briefed on Operation Northmoor on the 16th of September of 2016. The conclusions of the former Chief Constable included that the Operation Northmoor investigators had not followed a conventional reactive strategy from the events and evidence already established, and that further hoped-for lines of inquiry were unlikely to come to fruition, and that he would have expected more and more concrete progress given the time for which investigation had already run. He suggested two immediate measures to improve the effectiveness and efficiency of the investigation into the alleged extrajudicial killings. The first was that the investigation should be refocused along conventional lines, and second, that there should be an external review of the operation for assurance purposes. Accordingly, an independent review team comprised of 2 retired senior detectives was also established at the end of 2016. The assistance and support that had hitherto been provided by the external policing agency was discontinued. In November 2016, the original terms of reference that I've just outlined were redrafted to make it clear that Operation Northmoor was a police investigation responsible for investigating criminal offences consistent with the RMP's function under the Armed Forces Act, rather than a more general inquiry into operational practices or working culture. Accordingly, any systemic issues or wider lessons to be learned were removed from the remit of the investigation. Any such matters, if they were identified, were to be referred to the MOD Systemic Issues Working Group. Between the 5th and the 13th of January of 2017, the independent review team conducted a review of the investigations carried out by Team 1 of Operation Northmoor. And in a report dated the 24th of January of 2017, the independent review team offered its conclusions as to the progress of that team. Can I please ask that document 50 is brought up on the screen, and within that document, can we please turn to page 6? 3 passages have been highlighted on this particular page that sit under the title Independent Review Team's Initial Response to the Senior Investigating Officer's Presentation. And if we look to paragraph 4.2 and then below. At this time, it was readily apparent that there is no evidence in relation to any individual who took part in the raid of Operation Tyburn, or indeed any other alleged connected incidents. The information is untested, untried, and without provenance. It remains at this current time of a poor quality and cannot support the contention that criminal offences have taken place. And then in paragraph 4.5, dealing specifically with the designated 2 suspects, N1141 and N1201. The suspect designations in connection with N1141 and N1201 are premature, without foundation, and at this current time profoundly unhelpful to the progression of Operation Northmoor. In addition to that change of focus, the independent review team recommended that specific lines of inquiry be progressed, including deployment to Afghanistan to obtain witness evidence, the taking of statements from all individuals involved in Objective Tyburn, and the investigation of the other 10 DDOs that were part of the TTP review. Thus, on the 23rd of February 2017, Provost Marshal Army decided that those 10 DDOs should be brought within the scope of Operation Northmoor. On the 17th of October of 2018, a formal decision was taken that 2 DDOs which were part of the TTP review should be investigated in depth, since they showed the same imbalance between the number of EKIA and the number of weapons recovered. They were the second example that I took you through yesterday, Objective 1, a DDO that took place on the 7th of February 2011, and which resulted in 9 fatalities, but the recovery of only 3 AK-47s. And then the third example that I took you to yesterday, Objective 2, that took place on the 9th of February 2011, and resulted in 8 fatalities, but the recovery of only 4 AK-47s. The investigation into Objective Tyburn therefore continued along the new strategy proposed by both the IAG, the Independent Advisory Group, and the IRT, the Independent Review Team. And it included focusing on interviewing the subunit commander, interviewing members of the subunit, interviewing the supporting personnel, and interviewing members of the Afghan partner unit. All were to be interviewed as witnesses. The same strategy was also utilised for the investigation into Objectives 1 and 2. The interviews took place between 2017 and 2019. When interviewed, most of the 10 members of the subunit could not recall the operations, and those that did gave accounts consistent with lethal force having been used in self-defence. The 11 supporting personnel also could not recall the specific operations, and the 7 officers from the APU could provide no evidence of any wrongdoing on those operations. The independent review team continued to provide assistance to progress the investigation and review ongoing lines of inquiry throughout this period and up to their departure report in April 2019. And in that report, on the 12th of April of 2019, they offered the following conclusion. Can we please look at document 51, and within document 51 to page 6. We can see here in the report signed off, we see in the bottom, on the 12th of April of 2019, the conclusion at paragraph 13. The independent review team continue to be impressed with the positive, tenacious and professional ongoing approach by the senior investigating officer and his investigation team. They continue to be open and realistic about the investigation and always adopt a thorough and comprehensive approach to all arising tasks. The independent review team are of the opinion that Operation Northmoor should now consider all aspects in connection with a suitable exit strategy. The independent review team believe that the inquiries and extensive work carried out today has been robust, thorough, and will be able to stand scrutiny from any third party. At this stage, there were still a number of lines of inquiry outstanding, including interviews with some members of the APU who had served with UK Special Forces. Investigators were deployed to Afghanistan in the early summer of 2019 to conduct those interviews. Of the APU soldiers who were interviewed, only one could recall the operation, and he did not describe anything illegal or untoward taking place. However, during an interview on the 2nd of July of 2019 with N7058, an APU soldier, an allegation of criminal conduct against UK Special Forces was made. It was claimed in his interview that an English soldier had carried an old AK-47, which when he killed someone, he would place beside the body. That APU officer was asked to return to make a formal complaint, but he did not do so. On the 15th of July of 2019, Provost Marshal Army decided that following a thorough and independent investigation in which all reasonable and proportionate lines of inquiry have been pursued, there was insufficient evidence to support a prosecution for any of the unlawful killing allegations that had been raised. That decision was endorsed by the Independent Advisory Group and by the Director of Service Prosecutions. Furthermore, in light of the outcome of the investigations into Objective Tyburn and Objectives 1 and 2, it was decided that further investigations of the other 8 DDO operations that had formed part of the TDP review was not warranted. Following statutory consultation with the Director of Service Prosecutions, Provost Marshal Army concluded that the operation would be closed, and a report for the 3 principal DDOs that had been investigating was then sent to the Systemic Issues Working Group for their consideration to be given to any non-criminal systemic issues that might require attention. On the statutory request for advice from the Service Prosecuting Authority, reference was made to the interviews in theatre. None of the APUs spoken to recalled the operation and made no mention of criminal or untoward behaviour on the part of their Special Forces counterparts. No further offences were identified by the witness. The caveat is given that this was based on a verbal briefing only, and that the senior investigating officer had not yet had the chance to review all the material. In the final Gold Group executive summary, the following conclusion was reached in respect of Operation Northmoor. And can we please look to document 52 and within that document to page 37. This has been a large and highly complex major inquiry which has been extensively assured. However, due to the very nature of those being investigated, there has been rumour, conjecture and hearsay with regards to potential incidents. Despite all reasonable and proportionate evidential opportunities having been explored, to date there is no cogent or tangible evidence to prove or support that unlawful killing took place. Whether that conclusion was correct will be for the inquiry to determine, and in order to do so, we will scrutinise the way in which Operation Northmoor was handled, both by those in charge as well as by those who carried out the investigation itself. In 2022, during the judicial review proceedings brought by the Saifullah family in respect of Objective Tyburn, the Secretary of State for Defence conceded that the RMP's investigation into these deaths was not commenced sufficiently promptly, and further, there was not an adequate investigation of systemic issues. Therefore, it is clear that questions remain over the investigative strategies pursued, over the key decisions made, and over the ultimate conclusions that were reached. Whilst it is now beyond doubt that concerns were being raised at the time of the DDOs, those allegations were not communicated to the RMP at the time. And apart from Operation Sestro, which surfaced 2 months after the DDO had occurred, the matters being investigated were not brought to the attention of the Royal Military Police for 3 years. And yet the Armed Forces Act requires a commanding officer to make a report to the RMP as soon as is reasonably practicable if a reasonable person would consider that a serious offence may have been committed. the timeliness of the reporting in this case will be considered by the inquiry. What impact that had upon the investigation and the memories of those involved will be for this inquiry to assess. The claim of many that because of the passage of time they could not recall the particular DDOs will have to be critically examined. And the problems that were faced by the investigators when it came to gathering the relevant evidence will need to be reviewed with care. What matters is not the criticism of others, especially uninformed criticism, since even high-level criticism is without value when it is based on nothing more than an assumption about what might have happened. The inquiry will need to focus on the actual investigations that were conducted and to scrutinise the actions of the investigators. During the course of Operation Northmoor, it was obvious to the investigators that the recovery of the contemporaneous material that was generated by UK Special Forces during the course of the DDOs would need to be examined, and that was essential. It was discovered that the operational data was sent to a number of different servers. The Royal Military Police recovered a forensic copy of the UK Special Forces headquarters in Afghanistan server, and they also considered it necessary to do the same with the server based at the headquarters in the UK. That server is known as ITS-1. Efforts began in October 2015 to recover either the server itself or its contents. UK Special Forces were concerned that the server held data for irrelevant operations and from other theatres, and they were anxious that there should be no impact to their operational capability. However, despite repeated efforts, the matter remained unresolved 10 months later. Despite the protracted negotiations, on the 15th of August of 2016, the senior investigating officer recorded the following entry in his policy log. Gold has directed that we attempt to recover the data set amicably without the need at this stage to do so using our prerogative powers. The Operation Northmoor investigators were informed that the data was due to be migrated from the ITS-1 server to a new server. It was agreed that UK Special Forces headquarters would not modify, change or delete any data on the legacy server, and it was understood by Operation Northmoor that this server would be made available to them. However, on the 12th of December of 2016, the senior investigating officer recorded the following entry in his policy log. I will be seeking to recover the system as a whole on this date. An agreement appears not to have been reached in respect of total recovery. I have in law the ability to recover ITS-1, and with the operational necessity removed, the redundant original server can be recovered in evidence. In December 2016, when the RMP attended to collect the server, they were informed that data had been deleted. The senior investigating officer recorded the following entry in his policy log. It appears that UK Special Forces headquarters have deleted material from the preserved ITS-1 server. That deletion process has been conducted in such a way that it is irreversible and impossible to determine what has been deleted. This is in direct disobedience to our demands to preserve the data in its entirety. The Royal Military Police concern about the impact of any deletion from the server was that it might now be impossible for Operation Northmoor to be satisfied that what had been transferred to the new server was the entire contents of ITS-1, and it might not be possible to exclude the risk that anything had been deleted before that transfer took place. The Royal Military Police were subsequently informed that they could have access to relevant areas on the ITS-1 server, but that full recovery was not yet agreed. On the 20th of January 2017, the senior investigating officer advised that the ITS-1 server should be recovered immediately, but the Gold Commander did not agree. On the 27th of January of 2017, the senior investigating officer emailed the Gold Commander to confirm the instructions that he had just been given, and that they were: 1, presently he should take no action in respect of data recovery from ITS-1, and 2, that he should take no action in respect of the deletion of data from the ITS-1 server. Accordingly, after nearly 15 months of negotiations to recover the entire data set from the UK Special Forces server, the senior investigating officer was instructed not to take any steps to secure what was promised, and not to investigate why it was that Special Forces headquarters in the UK had permitted data to be deleted. The issue with the ITS-1 server engages a number of the matters that this inquiry is required to examine: whether material was deleted, why it was deleted, and what prevented this being independently investigated are matters that the inquiry will consider with care. Whether this was, as has been suggested in some quarters, part of a conspiracy to cover up wrongdoing by UK Special Forces and designed to prevent Operation Northmoor from uncovering the truth, or whether this was simply the result of a server migration error, will need to be examined and determined in due course. The answer or answers will depend entirely upon the evidence, and it would be inappropriate to attempt to form any conclusion about what the evidence might show until it has been called. The inquiry's investigations to date suggest the following: the data transfer had been undertaken by contractors, and that the contractors, as part of the process to speed up the transfer, had run a program that had the effect of permanently deleting already deleted data. We anticipate hearing from the relevant witnesses at the end of the year, when it is expected that these issues can be properly examined and the evidence will become clear. As I said at the outset, this is one of the first major topics to which we will be turning, and in conducting that part of the inquiry, we are determined to demonstrate for all to see that the inquiry will not shy away from challenging the evidence that it uncovers, no matter the rank or seniority of the source of that evidence, and that it will reach conclusions that are based upon that evidence, no matter where they may lead. But what the inquiry will not do is rush to judgment on this or any other issue. The RMP committed huge resources to Operation Northmoor, and a vast number of inquiries were undertaken in the UK and in Afghanistan. Many witnesses were traced and spoken to. Many thousands of documents were sourced and reviewed. The ultimate result, that no arrests were made and no charges were brought, does not mean in and of itself that the investigation was a failure. And it does not mean in and of itself that those who worked day to day during the course of the 5 years were anything other than committed, professional, and trying to do a good job. What impact the passage of time had upon the investigation and the memories of those involved will be for this inquiry to assess. The veracity of the claim of many of those involved that they could not remember will have to be critically examined, and the problems that were faced by investigators when it came to the gathering of the relevant evidence will need to be reviewed with care. There are questions to be answered regarding the organisation of the investigation, the key decisions made, and the strategies pursued. That is why the inquiry is tasked with determining whether Operation Northmoor was timely, rigorous, comprehensive, properly conducted, and effective. The inquiry will examine the way in which Operation Northmoor was handled, both by those in charge as well as by those who carried out the investigation itself. It will consider, for example, overall strategy and key decision-making, including whether or not the significant change in strategy in 2016 was appropriate. And ultimately, it will determine whether Operation Northmoor was fit for purpose. There is no doubt that criticisms and complaints were circulating at the time within the chain of command about the conduct of UK Special Forces in Afghanistan. That is what led to the review of the TTP and ultimately to advice being given that it needed to be changed. There is also no doubt that despite the allegations that were being made both internally and externally about UK Special Forces, these matters were not brought to the attention of the service police at the time. That is what led the RMP to conduct a historic investigation in which the majority of potential witnesses claimed, whether truthfully or not, that they could not remember the events about which they were being asked. And what is clearly beyond doubt is that the 5-year inquiry failed to lead to anyone being charged, let alone prosecuted, for any criminal conduct arising out of the DDOs in which large numbers of Afghan males were killed, but very few weapons were recovered. That is what led to complaints being made about the efficacy and propriety of the RMP investigation. But whether the allegations that have been made about the extrajudicial killings, together with any cover-up, ultimately enable you to be sure that there is credible information about one or more of the matters under consideration, will be for you, sir, to determine once all the relevant evidence has been examined. But when we come to consider that evidence, it is important that everyone recognises and accepts that rumour, gossip and speculation are no basis for concluding that murder and the UK Special Forces are bedfellows, that regimental amnesia and a cover-up have been orchestrated to protect the reputation of British armed forces, or that the RMP inquiry was too badly led or poorly equipped to uncover the truth. You, sir, have undertaken to look for credible information, and no one who has any interest in the outcome of this inquiry would want you to make any finding that you were not sure was properly and adequately supported. Rumour, gossip and speculation are the enemy of the truth. And if this inquiry is to find the truth, then the only thing upon which it will base its findings will be the evidence. And I am able publicly to give you and all the interested parties and the wider public this undertaking, that your team will do all that we properly can to assist you in that endeavour. That's all I wanted to say by way of the opening statement. I anticipate now would be a convenient time for that short break before my learned friend Mr. Altman rises to his feet.
Indeed. Thank you very much indeed, Mr. Glasgow. We'll rise until 10 to 11, please. Thank you. Mr. Altman.
So thank you. On the 15th of December 2022, the Minister for Defence People, Veterans and Service Families, Dr. Andrew Morrison, announced in Parliament the establishment of this inquiry, which had been commissioned by the then Secretary of State for Defence, Ben Wallace, to investigate and report on alleged unlawful activity by British Armed Forces during deliberate detention operations, or DDOs as we have come to call them, in Afghanistan in the period from mid-2010 to mid-2013, and the adequacy of subsequent investigations into such allegations. In the announcement, Dr. Morrison said, among other things, and I quote, "The decision has been informed by two ongoing judicial review cases known as Saifullah and Norzai. The claimants in those cases assert that relevant allegations of unlawful activity were not properly investigated. The underlying events have been the subject of comprehensive service police criminal investigations, but the Ministry of Defence accepts that Operation Northmoor should have started earlier, and that there may be further lessons to learn from the incidents, despite there being insufficient evidence for any prosecutions." He continued, "The inquiry will be fully resourced and supported so that it can carry out its work and report expeditiously." He added, "The UK's armed forces rightly hold themselves to the highest possible operational standards. Operations must be conducted within the clear boundaries of the law, and credible allegations against our forces must always be investigated thoroughly. The service justice system is capable of investigating and prosecuting all criminal offences on operations overseas and here in the UK. Defence has worked hard over recent years to ensure that the processes in place to maintain justice in the armed forces are effective and that allegations of criminal wrongdoing arising from any future operations are raised and investigated appropriately. I hope," he said, "that the whole House shares my pride in our armed forces. They are renowned throughout the world for their courage, integrity, and professionalism. We are profoundly grateful for their service today, as we were while they were deployed at our behest in Afghanistan." And that ends that series of quotations. In bare summary, so as you well know, the inquiry's original terms of reference task it with determining whether the investigations carried out by the Royal Military Police, that's to say Operations Northmoor and Sestro, were properly and effectively conducted, whether there is credible information that extrajudicial killings were carried out by the British Armed Forces in Afghanistan during DDOs during the period of mid-2010 to mid-2013, whether the circumstances of any such extrajudicial killings were covered up at any stage, and what lessons there are to be learned. At the commencement of my submissions at the hearing of the Ministry of Defence's applications for restriction orders on the 5th of July, I explained that the then Secretary of State for Defence, Mr. Wallace, had decided to confirm that UK Special Forces were involved in the DDOs, which are the subject matter of this inquiry, and laid a written ministerial statement before Parliament to this effect that morning. in which Mr. Wallace said, quote, "This confirmation is made in the exceptional circumstances of this inquiry, where the activities of this organisation are the central focus of the inquiry's investigation as set out in its terms of reference. Outside of this very specific context, such confirmation should not be seen to alter the long-standing position of this government and previous governments to not comment on the deployment or activities of the UK Special Forces. I remain steadfast in this for the protection of those involved and our national security," end quote. The consequences of this avowal, so far as the inquiry is concerned, are twofold. First, paragraph 4 of the Ministry of Defence's open submissions seeking a restriction order in relation to the policy of neither confirming nor denying, or NCND, the alleged involvement of UK Special Forces was no longer pursued, and in relation to the use of the term Special Forces was formally withdrawn. And second, pursuant to Section 5, subsection 4 of the Inquiries Act 2005, on the 7th of August this year, Mr. Wallace agreed to revise the terms of reference in keeping with the avowal, so that the term British Armed Forces was replaced by the term UK Special Forces wherever it appeared in the original terms of reference. On the 19th of September this year, a further written ministerial statement was laid before Parliament, in which Grant Shapps, the new Secretary of State for Defence, confirmed that the terms of reference of the inquiry had been amended by agreement with you, sir, saying, quote, "The amendments reflect the written ministerial statement which avowed the involvement of special forces in alleged unlawful activity in Afghanistan in the period mid-2010 to mid-2013, end quote. In consequence, it is confirmed that UK Special Forces were involved in the DDOs which are the subject matter of this inquiry. In his written ministerial statement, Mr. Shapps also said, quote, "In my new capacity as Secretary of State for Defence, I would like to reiterate my strong support for this inquiry commissioned by the Right Honourable Ben Wallace MP," end quote. In this regard, the Ministry of Defence wishes to express, through me, and stress its enduring commitment to this inquiry and its continuing intention to provide its full cooperation so that the inquiry is able to fulfil the terms of reference set by the Secretary of State for Defence in establishing it. Respect for others is a fundamental value reflected in the British Army's values and standards. The importance of acting lawfully is also reflected in those values and standards. It's integral to all aspects of the UK Armed Forces and is instilled from initial training onwards. The Ministry of Defence thus acknowledges the extreme gravity of these allegations, which are at the heart of this inquiry, and is determined that the inquiry should follow the evidence and arrive at the truth. This opening statement draws on the open evidence thus far provided to the inquiry. It focuses on several key themes which appear to be material to the inquiry's terms of reference. They are the reason why UK armed forces were in Afghanistan during the relevant period of this inquiry, in other words, mid-2010 to mid-2013, and the legal basis for it, the Taliban insurgency and its strategy, tactics, and techniques particularly the increasing and devastating use of improvised explosive devices, or IEDs, from 2009 onwards, conventional army procedures for clearing a compound, the British Army's values and standards, UK detention policy and procedures, the number of UK service personnel deployed in Afghanistan, the number of casualties, and of those killed in action. And finally, the Ministry's continuing commitment to this inquiry. So against that background, let me begin, if I may, with the rationale for being in Afghanistan. During the relevant period of this inquiry, all UK armed forces in Afghanistan operated as part and under the command of the International Security Assistance Force, or ISAF, which operated under the authority of the UN Security Council and was a voluntary international coalition to which the UK was a significant contributor. ISAF had been established in December 2001 under UN Security Council Resolution, or UNSCR as I shall refer to them, 1386, following the Bonn Agreement concluded earlier that month. On the 4th of January 2002, a military technical agreement was signed between the interim administration of Afghanistan and ISAF, in respect of which the UK was at that stage lead nation, to establish their respective obligations. The agreement noted by Article Roman 4.2, quote, "The ISAF commander will have the authority, without interference or permission, to do all that the commander judges necessary and proper, including the use of military force to protect the ISAF and its mission," end quote, and agreed by Article Roman 4.3 that it should have, quote, "complete and unimpeded freedom of movement throughout the territory and airspace of Afghanistan," end quote. On the 23rd of May 2002 and the 27th of November 2002, UNSCRs extended the authorization of ISAF for further periods of time. On the 11th of August 2003, the North Atlantic Treaty Organization, NATO, took command of ISAF following the request of the UN and the government of Afghanistan. On the 13th of October 2003, a UNSCR resolution authorized the territorial expansion of ISAF's mandate to areas of Afghanistan outside of Kabul and its environ, and extended ISAF's authorization for a further period of time. Several additional UNSCRs extended ISAF's authorization into 2014. Let me now come to ISAF's mandate. ISAF operated pursuant to the UN Security Council mandate as articulated through its UNSCRs. Its mandate was to assist the government of Afghanistan in creating and maintaining security so that the government of Afghanistan and US personnel, UN personnel, could operate in a safe and secure environment throughout the country. UNSCR 1386, to which I've already referred, authorized, quote, "the member states participating in the International Security Assistance Force to take all necessary measures to fulfill its mandate," end quote, where necessary for reasons of force protection, self-defense, and to achieve the objectives of its mission, namely to establish and maintain a safe and secure environment. ISAF's mandate included authorization to stop, search, question and detain non-ISAF personnel. It's self-evident that in a counter-insurgency operation it was necessary to detain those individuals who constituted a threat to the security and stability of the country, especially if they constituted a threat to the lives of the population at large. The mandate to assist the government of Afghanistan must be understood in the light of the UN Security Council's repeated reiteration of its strong commitment to the sovereignty, independence, territorial integrity and national unity of Afghanistan, and repeated recognition that the responsibility for providing security and law and order throughout the country resided with the Afghans themselves. I come now to say a few words about Task Force Helmand. During the relevant period, there were 8 six-month rotations of UK conventional forces on Operation Herrick in Afghanistan. Operation Herrick was the operational codename under which all British operations in Afghanistan were conducted from 2002. UK Special Forces operated alongside and in support of conventional forces throughout the relevant period. From the 3rd of July 2010, all UK forces in Helmand were operationally under the command of ISAF Regional Command, or RC, Southwest, which was a 2-star headquarters based at Camp Leatherneck, the US camp co-located with Camp Bastion in central Helmand, and commanded by a US Marine Corps officer. Prior to the creation of RC Southwest on that date, UK forces in Helmand were operationally under the command of RC South, based at Kandahar Airfield. To the extent that the reporting structures applicable to UK Special Forces were different, they can, if necessary, be explored in closed evidence in due course. Task Force Helmand was based on a UK manoeuvre brigade and was commanded by a UK 1-star officer, in other words, the brigade commander. The task force was responsible for the delivery of all land tasks in its area of operations. I come now to describe the strategies and tactics, techniques and procedures used by the insurgency. The insurgents in the relevant period were generally labelled as Taliban or the Taliban, though the situation on the ground was more complicated. The senior leadership of the insurgency in southern Afghanistan was based in Quetta, Pakistan. In the relevant period, the insurgency in Helmand in southern Afghanistan operated a system of shadow government at province and district level. The structure of Taliban command matched that of the Afghan government. The strategy of the insurgency was broadly first to impose casualties on ISAF, to encourage ISAF to leave Afghanistan. Second, to undermine the rule of the Afghan government by direct attacks on the Afghan National Defence Security Forces, ANDSF for short, and civilians working for the Afghan government. And third, to control the local population in part through intimidation and in part through its shadow governance system. Beyond its core leadership structure, however, the Taliban was often described in ISAF and UK assessments as a franchise movement because several groups who were not ideologically committed to the Taliban fought for the insurgency for their own reasons. Thus, many Taliban subgroups were from a particular tribe which, due to the local political situation, was opposed to the Afghan government and which was backed by other tribes. Other Taliban subgroups were effectively narco gangs who had no ideological affinity with the Taliban but fought with them opportunistically. Insurgent fighters were commonly described by ISAF in terms of three tiers. Tier 1, these were the full-time fighters who were the minority but the ideological core. Tier 2 were the part-time fighters. These were from groups whose motivations varied, which formed part of the wider Taliban franchise. And Tier 3 were the enablers. This comprised a range of persons who enabled the insurgency in various ways, from specialists, such as the makers of IEDs, to members of the local population, who acted as scouts and informants for the insurgency. The insurgency in southern Afghanistan relied on specialized networks for certain functions, such as the manufacture of IEDs and the deployment of suicide bombers. The insurgents in Helmand continually adapted their tactics, techniques and procedures, or TTPs, as they are commonly referred to, in response to the changing approach of ISAF and the ANDSF. Common targets for the insurgency included coalition operating bases, training establishments, temporary patrol bases, and lines of communication, particularly roads that linked coalition bases. The insurgents' TTPs at the tactical level included, first, the reconnaissance screen. In order to defend themselves against ISAF and the ANDSF, the insurgency would typically operate a reconnaissance screen near coalition patrol bases, which would inform them of movements by ISAF and ANDSF forces. The reconnaissance screen was simple and composed of individuals, often children, with radios. Second, IED belts and mobile defense. Behind the reconnaissance screen, IED belts were utilized to defend insurgent areas. IED obstacle belts were often covered by small arms and rocket-propelled grenade launchers, RPGs, from multiple firing points. And where coalition force operations were anticipated, complex bunker systems were constructed. Bunkers were often booby-trapped in order to target coalition forces who cleared them. Insurgents also routinely fought from compounds which they took over from local people for that purpose. Insurgents would generally fight back from compounds or bunker positions in a system of mobile defense. Third is counter-surveillance. The insurgents developed an understanding of ISAF TTPs and sought to exploit them through observation. Weapons and ammunition were placed in prepared hides, allowing unarmed insurgents unhindered movement between locations. Children were used as human shields to protect those laying IEDs or to move weapons. Those placing IEDs were conscious of the threat from overhead surveillance, and because of that, limited their time on task and took cover at frequent intervals to evade detection. Fourth is conventional attack. The initial stages of a tactical level attack, termed a contact by UK forces, by the insurgents, would typically see a high rate of fire for 2 to 3 minutes, followed by attempts to flank coalition forces. The typical length of contacts was relatively brief, usually 15 to 20 minutes, as the insurgents would normally try to break contact before ISAF forces could target them with other assets, whether from indirect fire, air, in other words, fixed wing, or aviation, in other words, helicopters. Fourth is counter-air assault. Insurgents understood the threat from air assault and would attempt to analyze likely landing zones and consider how best to counter any such operation. They understood coalition airframes, including attack helicopters and medical evacuation helicopters, and adapted their TTPs accordingly. Sixth were suicide attacks. Suicide bombers were relatively rare, but suicide bomber attacks happened occasionally, whether by individuals on foot or in a vehicle. Seventh, green on blue attack, so-called, a technique used by the insurgency from 2009 onwards, was to encourage soldiers of the Afghan National Army, ANA for short, or members of the Afghan National Police, ANP, to attack their ISAF partners. These were known as green on blue attacks. And this was achieved in part by infiltration of insurgents into these organizations, and in part through the indoctrination of ANA and ANP personnel who were already in service. And lastly, and eighth, use of human shields. Insurgents often used civilians as human shields. Women and children were commonly used to hide behind and fire from a position in the knowledge that ISAF would seek to avoid civilian casualties. IEDs were used by the insurgency in Helmand before 2009, but they weren't used systematically or at scale. Rather, in the period 2006 to 2008, most insurgent attacks on ISAF forces involved small arms, such as AK-47s and PKMs, which are machine guns, as well as RPGs, but occasionally also heavier weapons. From 2009 onwards, while the insurgents continued to use these weapons in combat with ISAF and ANDSF forces in Helmand, the use of IEDs increased dramatically. IEDs were used not only to harm ISAF and ANDSF forces, but more generally to reduce their ability to maneuver. Movement through areas with a high IED risk is slow, often very slow, as well as dangerous, and soldiers become more weighed down with the extra personal protection and anti-IED equipment needed to mitigate that risk. The IED risk continually evolved as the insurgents sought to defeat the countermeasures put in place by ISAF. For example, the amount of metal used in pressure plate IEDs was continually reduced to avoid being sensed by metal detectors. Two distinct groups of IEDs were used by insurgents in Helmand. First, externally sourced, custom-built items, which were mass-produced and transferred into Afghanistan along established logistic supply routes. Second, locally produced, simpler devices such as pressure plate IEDs. There were no rigid construction templates, and insurgents would use any available material suitable for the task. Component parts for IEDs were regularly smuggled across the border from Pakistan. And there were four main device types. First, the command wire or command pull. These devices initiate when an electrical circuit is completed. The command wire would be concealed utilizing natural features and camouflaged to match its surroundings. Second, radio controlled. a radio-controlled IED that has no physical link between the firing point and the device. Third was victim-operated. This type of IED is initiated when a person steps on or a vehicle drives over a pressure plate. And these devices were, of course, indiscriminate and frequently caused civilian casualties in Afghanistan. And fourth, secondary IEDs, a common technique, was to leave secondary IEDs in places where it was anticipated ISAF and ANDSF forces would take cover when a primary IED detonated. Let me say a few things about procedures for compound clearing. The conventional army developed guidance to clear compounds and buildings during Operation Herrick. To the extent there are any differences between conventional army and UK Special Forces compound clearance procedures, they can, again, if need be explored in closed evidence in due course. Compound clearance was defined as the act of gaining entry to a building or compound, either by verbal negotiation or manual or explosive means. Compounds were classified as a vulnerable area, and conducting a clearance required an operationally legitimate reason. The principal reasons were collection of intelligence and information, exploitation of arms and munitions in order to increase attrition on the insurgent network, gaining and maintaining popular support, offensive operations by denying use of the compound as a safe haven for insurgent groups, search operations, and arrest and detention if an insurgent threat had been positively identified in advance. Two key sets of guidelines affected compound clearance operations. The first of those was President Karzai's 12 criteria of the 30th of October 2009, or the Karzai 12 as they were called, which of course refers to Afghanistan's then newly re-elected President Hamid Karzai, and a dozen rules set down by General Stanley McChrystal, the commander of US-led forces in Afghanistan, which were essentially designed to maintain good relations with the community. And the second set of guidelines was the Command ISAF Night Raid Tactical Directive of the 23rd of January 2010. The method of entry used by troops to gain entry to a compound was dependent upon assessment of the threat, the mission, the task, the ground, and the available partner force. I now move on to describe British Army values and standards. And I emphasise, sir, that the emphasis is on the British Army. The Royal Navy and the Royal Air Force have their own sets of values and standards, but the inquiry's focus, and indeed the focus here, is on the Army. The British Army's operational effectiveness, and therefore its credibility, is intrinsically linked to its values and standards. These standards determine what actions are taken, and its values dictate how those actions are executed. Respect for others, as a fundamental value, is reflected in the British Army's values and standards, as is the importance of acting lawfully. The values and standards underpin all facets of the UK Armed Forces and are instilled from initial training onwards. The British Army's commitment to the importance of acting lawfully in all forms of operation can be seen most clearly in the training received by all members of the British Army on the Law of Armed Conflict, or LOAC for short, Members of the British Army are required to undertake operational law training during their initial training and through their military service. Officers and soldiers also routinely receive instruction and legal advice on LOAC from Army Legal Services branch officers when undertaking specific training for operations or as part of specialist roles they may be called upon to undertake. Such training and legal advice is consistent with the Joint Service Publication Manual of the Law of Armed Conflict and covers topics and content including use of force, rules of engagement, or ROE as they are referred to, as well as the treatment of captured persons. Which leads me to describe UK detention policy and procedures. When undertaking military operations, the armed forces must have the opportunity to detain individuals, to accept the surrender of a person who poses a threat to them and the mission, and they must be able to engage an adversary. In operations conducted in Afghanistan, it remained vital that UK armed forces had the authority and capability to deal effectively with individuals who represented a serious threat to UK troops, UK allies, and those the armed forces were there to protect. During the relevant period, detention operations whereby an enemy combatant was detained by UK forces were not generally pre-planned and often took place during a patrol or contact. By contrast, DDOs were generally pre-planned and conducted against high-value targets. The context in which these detentions occurred was of significance. At this time, UK armed forces, which formed part of ISAF in southern Afghanistan, operated in one of the most dangerous and challenging regions of the country. The constant threat to UK armed forces, Afghan forces, and the civilian population was very real in Afghanistan, as the number of military fatalities and the number of injured personnel, many with life-changing injuries, including the loss of limbs, attest. The majority of those detained by UK armed forces were suspected insurgents, including members of bomb-making cells. Detentions carried out by UK armed forces acting as part of ISAF in common with ISAF troops from other nations were conducted under the authority confirmed by the UNSCR, to which I've already made reference. Let me come to relevant ISAF detention policy. ISAF ROE authorised detention where detention was necessary for ISAF force protection, for self-defence of ISAF or its personnel, and for accomplishment of the ISAF mission. ISAF detention authorities were set within these ROE. ISAF standard operating procedures concerning detention of non-ISAF personnel, SOP 362 in particular, to which reference was made by Mr. Glasgow yesterday, authorised detaining forces to use force to restrain a violent detainee or to stop a detainee escaping. Deadly force was not to be used unless necessary to prevent an act constituting an immediate threat to life. Persons detained by ISAF were to be treated with respect and dignity in compliance with applicable LOAC, otherwise known as international humanitarian law and human rights law. SOP 362 distinguished between planned and unplanned detention operations. ISAF policy distinguished between different forms of entry onto a compound for the purpose of house searches ISAF were permitted to conduct night raids as a course of action. The ISAF Night Raid Tactical Directive, which I mentioned earlier, set out requirements for ANDSF partnering, method of entry, searches, and providing notification in respect of any person detained. Such operations were to be Afghan-led and coordinated with the government of Afghanistan, ANDSF, and local elders whenever possible. Every participant in a night raid was to comply with LOAC and use the minimum force necessary to achieve the mission. Distilling down to relevant UK detention policy and procedures at a strategic level, the Secretary of State for Defence issued a policy statement in 2010 on the strategic detention policy of the Ministry of Defence, which applied during the relevant period. The policy stressed the importance of the humane treatment of detainees and that the upholding of the UK's international obligations was key to operational legitimacy and success. It also outlined the minimum standards that must be applied for any operation, including that detained persons are held in accordance with host nation, UK and international law, with the standards of Common Article 3 of the Geneva Conventions, which must be met. There must not be transfer to a nation where there is a real risk of torture or serious mistreatment, and to ensure procedures are in place to investigate allegations of abuse. The policy also explained the governance of strategic detention within the Ministry of Defence, including responsibilities for ownership at doctrinal, policy and operational levels. It made clear the responsibility of all members of the armed forces, civil servants and contractors to inform their superiors and the Provost Marshal Army if they had concerns about any element of detainee handling. An example of the application of this policy in practice is provided by the UK response in April 2012 to concerns regarding the treatment of detainees. The UK issued a moratorium on the transfer of UK-captured detainees to Afghan detention facilities in Lashkar, which was only removed once the Ministry of Defence had ensured that there was no real risk of serious mistreatment or torture in line with the stated policy. The broad policy framework for detention operations by UK armed forces that applied during the relevant period was also explained and developed in other publicly available documents, namely the Joint Doctrine Publication, JDP 1-10, and the Cabinet Office Consolidated Guidance to Intelligence Officers and Service Personnel on the detention and interviewing of detainees overseas, and on the passing and receipt of intelligence relating to detainees. More specifically, for Afghanistan, the requirements of the JDP 1-10 were expanded into theatre-level doctrine in the form of Standard Operating Instruction, SOI, J3-9. This became the key operational guidance on detentions, which was used by UK armed forces operating in Afghanistan during the relevant period. J3-9, which was subject to regular revision, set out the procedures for the correct exercise of powers of stop, search, questioning, and detention by all UK armed forces operating in Afghanistan during the relevant period. In doing so, it implemented ISAF SOP 362, which I've referred to more than once already, for UK armed forces. For instance, it replicated the ISAF grounds for detention, explained the minimum standard of treatment which applied, and procedures to be undertaken during and after detention, and outline the information management and record keeping which was required. Finally, specific practical advice and guidance on detention within an operational context was provided to UK Armed Forces within the legal section of the Operation Herrick Individual Aide-Memoire. This document was provided to assist operational deployments. Version 5 was issued in February 2010, and version 12 was issued in September 2013. Dealing with the deployment and number of casualties and those killed in action, albeit shortly at this stage, the total number of UK service personnel deployed to Afghanistan between the 1st of January 2010 and the 31st of December 2013, which embraces the relevant period, was 93,140 individuals. And taking a much wider period from the data set available, between the 1st of April 2006 and the 30th of November 2014, so a period of roughly 8 years, a total of 402 individuals were killed in action or died of their wounds, and a total of 2,319 individuals sustained physical injuries on the battlefield. Finally, please, sir, let me say this. The Ministry of Defence remains committed to assisting your inquiry so that it fulfills its terms of reference. To this end, it has devoted and continues to devote considerable time, effort, and resource to it. The Ministry has already disclosed a considerable number of documents to the inquiry. It's disclosed 600 open documents in the Cy Fuller Judicial Review and 333 open documents in the Norzai Judicial Review. The Ministry has also served 4 substantial open corporate witness statements running to 157 pages, together with 89 exhibits comprising open items, as well as what we call closed to be open items, in other words, those which are going through a redaction process so that they may be disclosed in open. And they run to a total of 6,468 pages of material. Moreover, the Ministry of Defence continues to work closely with the inquiry legal team to ensure the full and efficient discharge of the inquiry's important work. As the inquiry commences its evidential hearings over the next few weeks, the Ministry of Defence remains committed, sir, to providing its full cooperation to your inquiry. So that's all I have to say at this stage.
Thank you very much. Thank you very much, Mr. Altman, to you and your team. We'll break now until 5 to 12, please, if that's all right.
Thank you.
Mr. Greaney.
So, thank you very much. Soldiers on military operations are not outside of or above the law. On the contrary, they're subject to a rigorous framework that incorporates the domestic criminal law as it applies to all UK citizens, service law under the Armed Forces Act 2006, the law of armed conflict and international humanitarian law, the rules of engagement set for a particular theatre or operation, and the British Army's values and standards to which Mr. Altman has referred. Where soldiers on military operations, including members of UK Special Forces, are alleged to have stepped outside of that framework in a way which engages the criminal law, it is the responsibility of the Royal Military Police, the RMP, as a service police force to investigate the allegation and present the evidence it gathers to the Service Prosecuting Authority for a decision on charging for the most serious offences. When the RMP is made aware of potential offences, it believes strongly that they should be investigated fully and effectively, whatever the nature of the offence and no matter with which unit the suspect serves. At the end of the investigation, if the evidential sufficiency test, to which Sir your counsel has referred, and which we will explain further in due course, but if at the end of the investigation that test is met, then there should be a referral for a charging decision, but if it's not met, then the investigation should be closed. And whatever the decision, whichever way it goes, it should be capable of withstanding scrutiny and commanding the confidence of both service personnel and the public. And so that is the firm belief of the Royal Military Police. The RMP therefore welcomes the commencement of evidential hearings in this inquiry. It would like to reiterate its complete commitment to supporting the inquiry in its important task. The Provost Martial Army, the PMA, is, as we all know, the head of the Royal Military Police. Brigadier Sarah Pringle-Smith is the current Provost Martial Army, and this inquiry is her top priority. Consistent with that, the RMP has provided around 1,200 documents to the inquiry, and its intention is to approach the inquiry with complete candour. So, having made those remarks of introduction, we'll turn next to the independence of the Royal Military Police. The RMP occupies a unique and, moreover, demanding position as a body of soldiers who are both part of the army and responsible for policing it. Save for the other branches of service policing, there is no similar institution within the United Kingdom. The ethos of the Royal Military Police is encapsulated by its motto, Exemplo Dicamus, or by example shall we lead. The Royal Military Police is committed to independent and effective policing of every part of the British Army, and that includes UK Special Forces. Policing UK Special Forces comes with inevitable challenges linked to their own distinctive circumstances, in particular the imperative of safeguarding national security. That imperative sometimes means that investigations must, as a matter of necessity, be approached differently. But in the final reckoning, the Royal Military Police firmly believes that national security cannot be permitted to take priority over justice. Structurally, the Royal Military Police is under the direction and control of the Provost Martial Army, an army officer in the rank of brigadier. At the request of the inquiry, the RMP has provided a witness statement dealing with many aspects of its structure and operation. It runs, I think, to 135 pages. That statement has been provided by a senior member of the RMP, Colonel Chris Rochell, who is present in the hearing room today. Colonel Rochel's witness statement sets out the framework that ensures and supports independence for RMP investigations, including under the Armed Forces Act, in King's Regulations for the Army, and in a series of decisions about force structure within both the UK and Afghanistan, which were intended to, and we believe did, enhance and protect the operational independence of service policing. It's worth noting, we suggest, that while the RMP's investigations are independent, the RMP itself sits within the broader context of the Army. In common with Home Office police forces, the RMP must decide how to prioritise its own resources and investigations. In contrast with Home Office police forces, while the RMP is valuable to and valued by the Army, it is also constantly competing for its resources, including personnel, within a much larger organisation. And those resource constraints can become more acute in the context of particular operations. As regards UK Special Forces, it has long been recognised that policing that community brings particular challenges, above and beyond those involved in policing the military generally. Since at least 2008, a protocol has existed and has been updated from time to time to facilitate effective policing of UK Special Forces while also maintaining operational and national security. RMP doctrine and policy recognise that this protocol, which was not binding on the RMP and could be departed from where that was necessary for investigative purposes, did not preclude or override the duty to investigate thoroughly, and, it stated, investigators should continue to see all relevant information and evidence when conducting investigations. So against that background, we'll turn to what in our written submissions we've described as the reality of operational policing in Afghanistan. Colonel Rochel's statement describes the history and functions of the Royal Military Police in the UK's Afghanistan campaign. Importantly, alongside investigations, the RMP had a number of other significant roles in Afghanistan. These included command and staff positions, close protection, training and mentoring of Afghan national security forces, and support to operational detention. As with all deployed units, handover and takeover procedures and rest and recuperation further affected the numbers available. So it follows that the number of RMP personnel deployed in Afghanistan at any one time did not mean all those soldiers were available for investigative duties. In the context of a cap on the number of British soldiers who could be deployed to Afghanistan, it was never open to the RMP to decide that it would simply deploy more investigators, because every additional RMP soldier deployed would mean one fewer infantryman, engineer, logistician, signaller or gunner. The Royal Military Police's investigative footprint in Afghanistan was, accordingly, relatively small. More fundamentally even than that, the nature of operational policing in a military context is very different from policing by a civilian police force. That difference starts with how an investigation is initiated, something we'll turn to, and then continues through all aspects of an investigation. And the RMP considers, indeed strongly considers, that a recognition and appreciation of that fact will be of importance to, sir, your work in this inquiry. In an operational theatre, such as Afghanistan, the use of lethal force is frequently entirely lawful, either in self-defence or defence of another under Card Alpha or under the rules of engagement. Indeed, in the context of operations in Afghanistan, in which, as Mr. Altman told us, more than 400 British service personnel were killed by enemy action between 2001 and 2014, the lawful use of lethal force by British troops in a non-international armed conflict was wholly unremarkable. It would, we suggest, be wrong and counterproductive for a criminal investigation to be undertaken every time a British soldier reported an enemy killed in action. Instead of that, the Army made use of a system based on review by unit commanding officers, or COs, who are under a statutory obligation under sections 113 to 115 of the Armed Forces Act 2006 to ensure that service police are made aware of any allegation or circumstances which would indicate to a reasonable person that certain offences, including murder, attempted murder, gross negligence or unlawful act manslaughter or war crimes have or may have been committed. Such a referral could, but did not have to, follow a shooting incident review, which we'll hear referred to as an SIR. A shooting incident review was required in any case where, and I quote, information indicates that civilians have been killed or injured by UK forces, end quote. A failure by a CO, a commanding officer, to discharge that obligation would be a service offence under Section 15 of the Armed Forces Act, as well as a breach of King's regulations and the Army's values and standards. Without referral by a commanding officer, the Royal Military Police was, and indeed remains, dependent on an allegation coming to its attention by other means. Where this occurs, those investigations are investigated. That was, for example, how both Operation Sestro in 2012 and the investigation into the actions on a further UK Special Forces objective in 2018 to 2019 within Operation Northmoor were initiated. But often such allegations are made substantially after the event, which renders the development of lines of investigation obviously more challenging. The allegation made through Lee Day, our solicitors for Mr. Bang and Mr. Cy Fuller, that there had been extrajudicial killings in respect of the deliberate detention operation against Objective Tyburn on the 16th of February 2011, for example, was not made until October 2014, 3 years and 8 months and 7 operational rotations later. And furthermore, as we heard from your counsel yesterday, those matters were not reported by the chain of command. Without either a referral or an allegation coming to its attention by other means, the RMP has no basis for initiating an investigation. Indeed, in all likelihood, it would have no opportunity to do so. The inquiry has rightly, in our view, called for evidence from, and I quote, anyone who has got any information or material which they think may be relevant to the inquiry, end quote. It may well be that this leads to new allegations coming to light of which the Royal Military Police was not previously made aware. And the RMP would not, it follows, ever have had the opportunity to investigate those allegations. The process of shooting incident reviews and referrals, whilst essential in the context of fatalities on operations, inevitably shapes the future course of the investigation that follows. It deprives investigators of what in policing is often referred to as the golden hour of investigative opportunities. That's to say, the period during which the best opportunity to protect preserve and gather evidence, including forensic evidence, is available. It also means that witnesses and suspects will in all likelihood have given an initial account prior to the investigation starting in order to inform the shooting incident review. Once an investigation has been initiated, the risks to RMP investigators are the same as the risks to any other British soldier in the theatre of operations. In Afghanistan, that meant an extraordinarily high risk to life and limb. As a result, for those investigators to be deployed to a scene, transportation and protection from combat units were required. And those combat units would have to be diverted from other missions for those tasks. The scene itself would need to be secured, which could not be done indefinitely, and time at the scene would therefore be limited. Sometimes access to a scene or to an individual witness would not be possible at all due to the level of risk to life involved. And moreover, the RMP's investigative responsibilities in Afghanistan extended far beyond the geographical area under the control of the UK's Task Force Helmand. And that might mean, in turn, that support was required from coalition or Afghan partners, particularly after transition to Afghan control. The Royal Military Police is the only UK police force that operates with such significant constraints on its initial investigations. Only the RMP has the training and the ability to operate in such a high-threat environment. But nonetheless, those constraints inevitably limit the kind of investigative inquiries that can be undertaken. So, as straightforward examples, it is unlikely that the investigation will have the advantage of a forensic, or in many cases any, post-mortem examination, a full, or again, in many cases any, forensic examination of the scene, or house-to-house inquiries, or other attempts to identify eyewitnesses. The only evidence from the scene may be photographs taken for other purposes by individuals who are not trained scene photographers. In the context, the specific context of investigations into allegations against UK Special Forces, there were further challenges, including the tempo of the operations of UK Special Forces, the fact that UK Special Forces operations did not always take place within UK-controlled battle space, the rotation of personnel out of theatre, which on at least one occasion led to witness interviews being conducted in an airport departure lounge in Afghanistan prior to interviewees returning to the UK, reflecting the level of importance the RMP gave to this process. And indeed, it will reflect the attitude of some personnel towards investigators, as we heard yesterday from Mr. Glasgow, and the need to avoid compromising national security or the operational security of UK Special Forces. At the end of an investigation by the Royal Military Police, the investigator's duty under Section 116 of the Armed Forces Act 2006 is to consider whether the evidential sufficiency test is met. This involves considering whether there is sufficient evidence to charge. If the test is met, then for a homicide offence, the investigator must make a referral to the Service Prosecuting Authority, the SPA, which then takes a decision on whether or not to charge. So, it is not the RMP which decides whether homicide charges are brought, it is the SPA. Although the investigator can decide that the evidential sufficiency test is not met, where a serious offence is alleged, Section 116 requires them to consult with the Service Prosecuting Authority before doing so. The RMP, therefore, does not have the power to bring an investigation into a homicide offence to an end without at least some input from the service prosecuting authority. So that leads to Operation Sestro and Operation Northmoor. Consistent with the RMP's role and its commitment to the independent investigation of alleged offences, between 2012 and 2019, the RMP committed very significant resources and effort to investigating those allegations of extrajudicial killings by UK Special Forces in Afghanistan that were brought to its attention, primarily under the banners of Operation Sestro and Operation Northmoor. There were also a small number of discrete other investigations, as well as consideration of whether there had been any cover-up or command responsibility for extrajudicial killing allegations. Today is not, in our view, the time for a day-by-day or decision-by-decision review of those investigations. Colonel Rochel's statement sets out the broad sequence of events, whilst other documents, such as the Operation Northmoor Executive Summary and the witness statements of Colonel Morris and Major Sheether, provide more granular detail. Throughout the evidential hearings, the Royal Military Police will continue to support the inquiry in its exploration of how these investigations unfolded. And at this juncture, the RMP simply wishes to make 6 general observations that we hope will help to place the investigations in their proper context. First, as the Ministry of Defence did in the earlier judicial review proceedings, the RMP readily acknowledges that for a variety of reasons, Operation Northmoor was not conducted with sufficient promptness. Moreover, none of the RMP's investigations explicitly considered systemic issues. That said, consideration of systemic issues is not the function of a criminal investigation, and the RMP both considered the forensic significance of similar allegations and made referrals to the Ministry of Defence's Systemic Issues Working Group. That is the first point. Second, the RMP acknowledges that these investigations faced very substantial challenges. Many of those stemmed from the realities of operational policing for alleged offences within Afghanistan, which we have explained already. Others reflected the constraints of national security and the resourcing and management of investigations which were unprecedented in their nature and scale for the RMP. At the time, the RMP took steps to try to address each of those challenges and believes it overcame them sufficiently that the investigations achieved all they could reasonably have been expected to achieve. In short, that they were effective and adequate investigations. However, the Royal Military Police recognises that as well as significant delay, Operation Northmoor in particular faced significant policy, resourcing and investigative difficulties, particularly in its early stages. And the RMP is entirely open to the possibility that, on an objective view and with the benefit of hindsight, those may cumulatively be thought to have limited the effectiveness of those investigations. Whether that is ultimately the case will be a matter for the inquiry to determine, but the advantages of hindsight, we suggest, should not be downplayed. In particular, if there were to be such a finding by you, sir, the Royal Military Police considers that it should not extend to any suggestion that RMP investigators at the time were doing anything other than their best in difficult circumstances. The RMP believes firmly that they were. Third, the challenges faced by Operation Sestro and Operation Northmoor were not confined to matters taking place within Afghanistan. Many of the extended timeframes within Operation Northmoor were linked to the need for the investigation to operate at or above secret. As a single, although significant example, after Operation Northmoor was established in March 2014, it was not until February of 2016 that a suitable site at RAF St Morgan that could process secret material came into use for the operation. And the major incident room was not stood up, as it's described, for secret material until November of 2016. We would observe that it's extremely rare for civilian policing to be faced with similar constraints. The scale of allegations investigated by Operation Northmoor also posed resourcing challenges. In late 2015, Operation Northmoor took responsibility for all outstanding investigations following the end of UK military operations in Helmand. As a result, it examined almost 700 allegations from more than 150 individual complainants, although only 3 of these allegations related to homicide offences, and well over 2/3 were of inappropriate but non-criminal conduct relating to treatment of detainees. At its peak, over 1 in 3 RMP Special Investigation Branch, SIB, personnel were working on Operation Northmoor, as well as significant numbers of other personnel drawn from across the Royal Military Police. Fourth, recognising the challenges that Operation Northmoor in particular faced, the RMP sought external assurance. This initially came from what Mr. Glasgow described as external policing agencies, whose advice about the command structure of the investigation and the lines of inquiry it would be reasonable to follow was accepted and implemented by the RMP. It follows that there was, at the time, external scrutiny and advice. Subsequently, from September 2016, that external assurance came from an independent advisory group, which we'll hear referred to as the IAG, which comprised a former chief constable who was subsequently a professor of advanced policing studies and a senior criminal King's Counsel who was former First Treasury Counsel. The independent advisory group's primary recommendation was that an external review take place, and the RMP therefore established an independent review team, the IRT, consisting of 2 former senior detectives. The independent advisory group and the independent review team continue to provide input and advice through to the end of Operation Northmoor. As will be apparent in those circumstances, this was not an investigation that lacked independent input. Fifth, we consider it appropriate to mention the impact the investigations, again, particularly Operation Northmoor, had upon those who worked on them. For Operation Northmoor in particular, a combination of working in a remote location, in conditions which were austere by reason of the security measures in place, and working with inherently distressing material made it a difficult experience for some. Furthermore, some investigators were also subjected to intrusive behaviour by the media. While in any investigation into a death, the impact on the investigators cannot and should not meaningfully be compared to that on either the victim or the family of the victim, it is likely to be a recurring theme in the evidence the inquiry hears, we predict, that many of those working on these investigations were badly affected by them. It's important that we emphasise that all working on Operation Sestro, Operation Northmoor and all other RMP investigations were committed to obtaining whatever evidence they could and to following that evidence wherever it led. And for me to observe that is not merely puffed by the RMP, but was the view of the independent observers. Sir Jonathan Murphy, a member of the Independent Advisory Group, observed in his witness statement for the Cy Fuller judicial review proceedings, and again I quote, "The investigators were zealous in their conduct of an extremely difficult investigation," end quotes. Similarly, as your counsel, Mr Glasgow, explained this morning, in their report of the 12th of April 2019, the independent review team described how they were, quotes, impressed with the positive, tenacious and professional ongoing approach by the senior investigating officer and his investigation team. Sixth, and finally in terms of our general points to provide context, as a result of those investigations, as described in Colonel Rothschild's statement, 5 individuals were referred by the Royal Military Police to the Service Prosecuting Authority for consideration on charges on the basis that the evidential sufficiency test was met. 3 of those arose from Operation Sestro and 2 from one of the discrete operations that we referred to earlier. It follows that in each case, the Royal Military Police considered that were the evidence suggesting that the person committed the offence to be adduced in proceedings for the offence, the person could properly be convicted. In each case, the Service Prosecuting Authority, exercising its independent judgment and statutory function, decided not to bring charges. In Operation Northmoor, following statutory consultation with the Service Prosecuting Authority, it was determined that the statutory evidential sufficiency test was not met for a referral in respect of any of the allegations of extrajudicial killing or cover-up of extrajudicial killing. That position was endorsed by the Independent Advisory Group, which agreed that all viable lines of inquiry had been exhausted. We turn next to changes since 2019. As we have explained already, the Royal Military Police is committed to learning from all aspects of these investigations and welcomes the opportunity to improve and develop. If the inquiry identifies lessons for the RMP, sir, you can be assured that they will be learned and change will be implemented as a result. Operation Sestro finished in 2015 and Operation Northmoor in 2019. Between 2018 and 2021, there were 5 external reviews and studies of the service justice system, the SJS, including of the RMP. These culminated in the 2021 review of the service justice system by Sir Richard Henriquez, a former High Court judge who produced what is often referred to as the Henriquez Review. Altogether, these made in excess of 200 recommendations to various bodies within the service justice system, including service policing. Virtually all of those relating to service policing have been implemented. The most significant development in that regard is the formation of the Defence Serious Crime Command, the DSCC. This was formed in December of 2022, and it brought together the special investigation branches of all 3 service police forces into a single unit headed by a new Provost Marshal Serious Crime. This represents a sea change in investigative structure that was recommended by the Henriquez Review and which required primary legislation to implement. It reinforces the independence of investigations into the most serious offences, as well as providing enhanced investigative capability by pooling the resources that previously belonged to all three service police branches. Where allegations of extrajudicial killing have been reported since the Defence Serious Crime Command was formed, investigations into them have been carried out by that command, not by the RMP. This is far from the only significant change. The position of Service Police Complaints Commissioner was created and filled in June of this year. The Defence School of Policing and Guarding has been accredited by the College of Policing to deliver UK standard investigative training at all levels below Senior Investigating Officer. There has been substantial investment in information management, with the Connect system being rolled out from October of this year. And that system is widely used across UK policing and is, in the view of the RMP, a significant step forward in how the service police utilise and manage information. It will substantially increase the RMP's investigative capabilities, and additionally, separate ongoing work will enable serious and complex investigations to be conducted at secret and higher. Each of these reviews and programmes of change take up effort and resources. Learning is a continuous and iterative process, particularly as no two military deployments are the same. So the challenges linked to policing deployments in Iraq and Afghanistan will not be the same as in the theatres of the future. But the Royal Military Police and service policing in general strive to learn and develop. Both recent and ongoing changes mean that current investigations function very differently from those which took place in the past. And investigations in future will have still greater capabilities, although it's right to observe that service police numbers and structures remain under constant scrutiny and pressure. We'll turn now to make some concluding remarks. As we've emphasised, the Royal Military Police is committed to assisting your inquiry, sir, to conduct a full and fearless investigation, in particular into whether the RMP's own investigations into allegations of extrajudicial killings and allegations of any cover-up were timely, rigorous, comprehensive, properly conducted and effective, a matter the inquiry's terms of reference, of course, specifically require to be investigated. Any assessment of that, we suggest, should take into account the operational realities that arise both from the reality of operational policing and the context of allegations against UK Special Forces. It should also, may we say, guard against any temptation to judge the investigations with the benefit of hindsight. Finally, the structure and shape of service policing has changed dramatically, even in the relatively short time since Operation Northmoor concluded. Those investigations would have been undertaken very differently today, but that does not mean that they were not adequate in their own lights. At the time, independent advice and scrutiny from a variety of sources, including the Service Prosecuting Authority, agreed that the evidential sufficiency test was not met for any allegations relating to extrajudicial killings investigated by Operation Northmoor, while it was the Service Prosecuting Authority's decision not to bring charges in relation to Operation Sestra. These were, the RMP believes, properly and appropriately substantial investigations staffed by RMP personnel doing their utmost in difficult circumstances. The RMP strongly believes that no organisation can learn unless it is held up to open scrutiny. Given the importance of both soldiers on military operations being subject to the law and on public confidence in the mechanisms that ensure that this is the case, the Royal Military Police welcomes the inquiry's evidential hearings and will not, so we assure you, shy away from any findings that suggest either failings in its investigations or make recommendations for the future. So that is what we wish to say at this stage.
Thank you very much, Mr. Greaney, to you and your team. That concludes the proceedings for today. We'll now adjourn, please, until 10 o'clock tomorrow morning. Thank you very much.